offense be secondary or primary?
This will be a primary offense. It will be just like the speeding and others. I also want to also tell very quickly, one of the reasons I'm so proud to have Representative Roan here is he was the author of the original distracted driving in Oklahoma. And when he first passed that piece of legislation to talk about distracted driving, they didn't even have cell phones. And so that's how long he's been here. Yes, ma'am.
Part of the criticism of the bill in the past was infringing on personal freedoms. How can you address that?
I appreciate people that talk about their personal freedoms and liberties, but the last time I checked, having a driver's license in Oklahoma was a responsibility. It wasn't a God-given right. It's not in the Constitution. You have a right. It says if you follow the guidelines and the standards that we've established, then you can have a driver's license. And if you don't follow those standards, then that privilege is removed from you because you can't follow the law. Whether it's, we've done that with drunk driving, DUIs, DWIs. Statistically, it says that texting is actually more serious and more distracting than driving while intoxicated. And those that have been involved in accidents and are survivors of that will certainly tell you that their injuries are just as serious. And that death was just as permanent because they were texting as opposed to having that bottle in front of them. So I will argue the point that this is it's a privilege that you're given in other ways.
Trooper Brown, perhaps I was hoping to get a law enforcement perspective on just how dangerous it is. Do you see this problem? And also enforcement, do you think it would be difficult to prove someone?
You know, we see it every day on a daily basis, and I'll say this, and a lot of times, we see it every day, and Sean, and I'll say that this, a lot of times, is more dangerous than the gun that I'm wearing on my head, especially when you're driving. This has cost a lot of lives already. So as far as policing the roadways and on patrol, it is very easy to see someone who has a digital device or electronic texting cell phone up above the steering wheel engaged in that process. I see it. I challenge anyone that would want to ride around with a highway patrol trooper to go out and look for it and see it as well. So as far as on patrol and seeing that, we see it already. Any kind of a law or bill that would take us a step further and try to ensure the safety for those who may not be engaged in that type of activity, that I think that would be a good thing. So, as far as our perspective, sometimes we police the ones that are the innocent victims out there on the roadway.
If phones are more dangerous than guns, why should we ban those phones then?
I'm sorry?
Why should we just ban them? Just don't let people have phones in it. They're that dangerous.
I think that a law is only as good as the people that enforce it. So as far as it goes, we see, I personally have seen a lot of fatalities on the roadway caused by texting. I personally have cleaned up those crashes, and I personally have knocked on those doors. So I'm speaking specifically on the cell phone issue. Again, anything that would try to save a life would be a good thing.
Let me ask you, if you saw someone texting, could you not pull them over for the distracted driving law?
Well, currently we've got laws on the books that have a precursor of being in a crash.
Okay.
So somebody that's been in a crash and we investigate the crash, there was an inattention element, then we can enforce that law.
But you couldn't actually do that when you're seeing someone texting while driving.
Yeah, this is secondary violation.
I want to make sure that I understand, because I was looking at the laws that are on the books, and we have a law that prohibits teenagers from using their phone in any way. And then Representative Duncan, I believe, passed a law, and it was put into effect in November, that allows the police officers to directly intervene if someone is driving. In fact, I'll admit, I was pulled over, I was digging in my purse, and I wasn't the slightest bit offended, because if I'm driving in a manner that's hazardous to other people on the road, that's what the police are supposed to be doing. So they have a bill that allows them, if they see you driving all over the road for whatever reason, and they're not limited to whatever the source of the distraction is, they can pull you over on the spot and give you a ticket for $100. So I guess what I'm asking is, that, am I understanding the law right?
Well,
Did you want to address that?
what we have currently is a secondary violation. If you're out there on the roadway and you commit a violation, let's say for driving left to center or an unsafe lane change, and you're stopped on that violation, and there was an inattention element, the way that we interpret the law is that you can be cited for the initial violation, for whatever violation that was, driving under the standard or acceptable change.
The operator of every vehicle while driving shall devote their full time and attention to such driving. And then it says that if the officer witnesses, it could be an accident, of course, but if they even witness you going off your lane and they think that you're being unsafe, they can pull you over and give you a ticket for $100, and they'll do it too. So my question is, I don't understand the focus on the phones because they're, I've looked at the studies, a lot of things that cause distractions. And even the governor's office of highway safety addressed some of these studies in their interim study from 2009. And they basically said, out of all distracted driving, and I know it's hard to get the numbers on that, I understand, that was one of the distractions. There were many more. So it seems like to me, Representative Duncan's bill from last year is all encompassing. And I think it's a really good law. You're not limited.
Let me tell you the difference. That says if a trooper or a law enforcement officer suspects that there's something going on, that they're distracting and they're moving, they're weaving, you can be texting and still be in a straight line looking like you're doing exactly what you're supposed to after you run over somebody and you didn't stop at the stoplight. We're trying to be proactive and say, you know what, even though it looks like everything's fine and they're not looking like they're potentially distracted, we know they are distracted because it says with statistical information, scientific study says if I'm looking at that cell phone and trying to manipulate it, I can't be looking at the road. I may be driving straight, maybe look like I'm following the speed limit, but that's not very much comfort after they run over my vehicle or a car has run under a truck. Because the trooper said, well, I really didn't have cause because they looked like they were driving safe, they were following their lanes, they weren't weaving back and forth. We're saying if the trooper or other law enforcement officer says there's a cell phone and they got it in their hand and they're looking at it, that's a violation of the law. And we don't have to worry about whether they were distracted or not, because at some point they're going to be distracted using that telephone. This gives them a cause of action, even if it doesn't look like they are being distracted. The law enforcement officer can look at that and say, oh, they've got a cell phone. That is not legal in Oklahoma under the provisions that they're using.
So in other words, presumption of innocence is just completely thrown out.
Well, you're not innocent if we pass this piece of legislation. You got that cell phone in your hand and you're punching the button. You are no longer innocent, I would think. If they can show in a court of law that you had that cell phone in your hand, you were manipulating the data, and you violated state statutes. Just like, I guess, if I'm driving while intoxicated, but as long as I'm driving straight, I may not be violating the law. I don't think that's right. If this is more serious than DUI and DWI, and we have those laws on the books, then why don't we focus on texting? It may not make a difference, but if it saves one life, or it saves one person from being injured, then we've done what we should have done.
Well, that's kind of what I'm worried about, because if we go on the basis of saving lives, which I went to EMT school, and the first awful wreck I saw was from texting and driving. So I totally understand. And the first thing I said was, there ought to be a law. Well, I've had, not so sure about that now, seeing how we got the one law that is encompassing of everything, allows the police to directly intervene. Because what I've seen is all over the country, they're having a real problem in enforceability. In fact, when this was brought up last year, an officer spoke and he said, the problem is we can't really tell. In the states that have had these laws for a while, some of them have only given 6 tickets, some of them have given none. And they're relying on their distracted driving laws because it's too hard to prove. So what they're going to need is additional tools and manipulation of current existing law that is there to protect our rights. They're going to need those laws to be changed to allow them more access in some way to our phones or our data. And that really concerns me. Does your bill do anything to address how this will be enforced? Because they can't see a lot of times when people are doing this.
My point is that we want to be proactive and not wait until after an accident has occurred. Because that's what everybody keeps referring to. Well, law enforcement can then investigate after the accident has occurred. We're saying we want to give the officers of Oklahoma the tool in their toolbox to say, I want to stop it before it happens. I've got probable cause because they just passed me and they're texting on their cell phone. They're not supposed to do that. I don't want to run down the road another mile and see that they run over somebody. Right now, if they're using a cell phone, that's not necessarily distracted. In the opinion of a law enforcement officer, they may say, you know what, they still look like they're manipulating the controls of the automobile fine. I didn't determine that they were distracted. You put a cell phone in their hand and we said, officer, if they have a cell phone in their hand, they're now in violation of the Oklahoma statutes. then obviously it's the officer's discretion to say, well, yeah, they were. And that's up to the law enforcement to make that. But we want to be very specific that the law enforcement officer has the opportunity to stop that motorist and say, were you in fact doing what I thought I saw you doing? I think that's what.
How are they going to know if they were doing it though? Because the person could just say they didn't do it without accessing the cell phone data or the records.
Well, ma'am, I'm not an attorney, nor am I a judge, but I would suspect that that's probably a lot of times in court when the law enforcement officer says, yes, I saw him doing that, and the other person said, no, I wasn't doing that. So I'm not an attorney, can't answer that. That's what the court of law is there to find out. Did they in fact violate the statutes as was presented by the evidence in that court? That's all we're saying. So let's give them another tool in their toolbox so that they will have the opportunity to present that evidence in the court of law to find out if in fact that individual, that the judge or the jury's discretion says yes.
Hey, Dan, I promise I'm not here to debate it with you. I want to ask on that, would you go through a little slower something you added at the beginning about why you think the data on the unintended consequences is not necessarily good data? Could you go through that a little slower again?
Let me just use Oklahoma as an example. Since 2007, there was a change in policy so that law enforcement does not necessarily have to ask that question or even obtain the data. You had an accident or you texted. That doesn't have to be asked. So my point here, Pat, is if law enforcement now asks that question, were you texting, and they say yes, then obviously if we've never had an accident with texting before because no one asked, then we've just increased it by 1. So the numbers, I think, will skew early on and say, yeah, gosh, we've got more people violating provisions. It wasn't a violation before. So now it will become a violation. And I think that's why the numbers sometimes when they're presented say, well, in states that have passed this law, there's actually been an increase in the number of texting accidents. Well, if you're never reporting those to start with, how can it be an increase? We don't have a good baseline to work from, I think, is my point here.
Just to clarify, your bill does not ban cell phone use as texting, but cell phone use in construction zone systems.
Correct. Right now, the language would read that you cannot use your cell phone to text or email, but you can still talk with your cell phone. You would be prohibited from using your cell phone in any manner in a school zone. And we hope to make the change soon before the committee to also include a work zone construction. And those fines will be commensurate with those.
How will they be able to tell the difference between someone just dialing their phone to make a phone call and texting?
I think law enforcement is probably smart enough to be able to do that with increased training. I would assume that anytime we put a statute on the law books, and I'm going to let the DPS address that law enforcement officers across the state are retrained, given new information about that particular statute and how they're going to look at the enforcement on it as is anything. Again, it's up to that law enforcement officer where they make that stop. We can give them all the laws in the world, but unless they're willing to make that stop and make that requirement, we may not know.
Do we know yet how much the price would be for a ticket?
Currently, the way we're going to write this piece of legislation is it would be just, for example, if you got caught using your cell phone in a school zone, it would be just like if you were speeding through a school zone. We didn't want to make a whole hodgepodge of different fines. We wanted to just lock this in and say it's just like if you do this. Here's the penalty that you will receive, so it's not all over the board.
So if you see this, pass, if this passes through, you see this as a precursor to possibly banning all cell phone use across the board, period, wildfire.
I'm not about to take on that project. I'm just telling the people of my district and the people of Oklahoma, at least in my emails and phone calls, conversations and letters, said
my bill would not include warrantless searches.
Okay.
Now, I thought recently there was a Supreme Court decision in some, or a federal district court that said, in fact, law enforcement could access your cell phone records even in a home. Doesn't have anything to do with driving, but if they find your cell phone and think you've been conducting drug activities on it, they have the ability to access your cell phone records. That's something the courts are going to have to decide, and that's where that's their function, is to determine it. But I have no intentions of opening this up to say that you've got the ability to do an unwarranted search.